Hello, everyone, and welcome to another episode of Chalk and Gavel. A few things before we get started. First, we would love it if you would rate and review Chalk and Gavel on your favorite podcast platform. That really helps us spread the word.
Yeah, and please consider supporting us on our Patreon site. It's patreon.com/chalkandgavel. Just $2 a month would really go a long way to enabling us to keep this show going.
And we're currently working on some potential subscriber-only bonus content. So get ready for that. We'll tease that here soon. We also want to encourage you all to check out the Education Law Association. The annual conference is coming up in November 6th through 9. Jamie is actually a co-chair on the conference committee this year, so he's been knee-deep in planning that. So come join us.
It's exciting.
It is. It's going to be a lot of fun. It's in Disney Springs, and Chalk and Gavel is going to be doing some events, so it'll be a good time.
That's right. All right. You ready to dig into this case?
Can a school deny academic credit as part of school discipline for work that has already been completed? Can a single disciplinary action impact a student beyond the school year? How far does a school's authority go? At what point during the semester should you just play it safe and leave your pot at home? That took a turn.
Weren't expecting that, were you? All right, in today's case, we go back to South Gibson High School in Indiana in 1998, where a zero-tolerance drug policy set off a chain of events that sparked a pretty interesting legal battle with some fascinating implications and plenty for us to think about. We have a student who got caught with marijuana and was expelled in the last few days of the fall semester of his junior year. The school took away the student's academic credit for the entire semester, even though he only missed the last 3 days for being expelled. And the Indiana courts really wrestled with that. So let's see how all this played out. This is the case of South Gibson School Board versus Sollman.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, before we start talking about marijuana and expulsions and things like that, Chris, what's our bell ringer today?
Yeah, so this is an interesting one that deals with a topic we've talked about a little bit. This is from an article from September 18th by Alison Klein that was published in Education Week, and it's reporting on another potential legal issue surrounding AI. So we've already talked about a couple of these with things like deep fakes and school discipline, but this is reporting on a report by Common Sense Media that found that Black students are more than twice as likely as their white or Hispanic peers to have their writing incorrectly flagged as the work of artificial intelligence. So basically, it's reporting that Black students are twice as likely as their white or Hispanic peers to be accused of using AI tools to cheat.
And who's doing the accusation? Is it AI that is flagging these things, or is it a teacher who's reading it and flagging it?
So it is...
Or a combination?
It's both, yeah. So the report talks about potential biases in AI detection software itself.
Oh, interesting.
And it also mentions, potential implicit biases or cultural mismatches with teachers, as well as potential sources of where this is coming from. But it reports on this study that some researchers did where they gave a bunch of AI detectors, and AI detectors that are supposed to detect whether or not something has been AI generated, take them all with a grain of salt, right? They're not perfect. And this study kind of shows some of the problems. This group of researchers took a bunch of essays written by Chinese students who were taking an English proficiency exam, and they took another set of essays from a bunch of American 8th graders whose native language was English, and they put both sets of essays, which were all human written, into these AI detectors, and the AI detectors incorrectly labeled over half of the Chinese students' essays as AI generated, while it accurately labeled the American 8th graders' essays as human written.
Wow.
So there's some potential biases baked into these AI tools. And that's something that we're learning more and more about with these AI tools, is that they are learning from the text and all of the inputs that we give them.
Yeah.
And part of that is they kind of internalize a lot of the societal biases and implicit biases, unconscious assumptions, whatever it might be.
Wow.
And so it just shows another point of caution with these AI tools, because this raises some really interesting potential issues around issues like race discrimination under Title VI, where, if you can show that a race neutral policy is having this kind of disproportionate impact, or that people are being treated differently based on their race, just because it's an AI tool, that doesn't necessarily absolve you of potential legal liability here. So there's a lot of things with AI that we need to be aware of. This is just another thing on top of that.
Wow. It's a bias upon bias.
It is. Yeah. And it could have some really serious implications, right? Because if you're being flagged for academic misconduct for using these AI tools, that can have pretty serious ramifications. So, add this to the growing research around different treatment for minority students in schools. We already know that there's huge discipline gaps. There's other disparities, right? So this AI tool, while we're trying to use them and leverage them to be, leverage their strengths, we also have to be kind of aware of some of the potential pitfalls as well. So the last thing I'll say about this is there's this quote from Amanda Lenhart, the head of research at Common Sense, the organization that put out this report, as saying, "We know that AI is putting out incredibly biased content. Humans come in with biases and preconceived notions about students in their classroom. AI is just another place in which unfairness is being laid upon students of color." So I think this is just another one of those situations where
we've got to be cautious.
Exactly. We've got to be cautious and be really critical of kind of the outputs, which is why people talk a lot about human-centered AI, or human in the lead is another term you'll hear, where basically AI can be a good helper, but it can't replace human discretion and decision-making.
Yeah. Human intelligence. Yeah.
What's that?
Well, it's very lacking in many of the cases that we discuss on this show, isn't it?
It's kind of the nature of the show, though,
I know,
right?
right?
We
rely on this.
Yeah, we kind of rely on, though, it's always fun to get an episode where everyone
does the right thing.
Everyone does the right thing, or at least has really strong arguments, right? This case, spoiler alert, I don't think is one of those cases.
No. Well, let's talk about it. All right. So, so here we go. We got South Gibson School Corporation, which is in Fort Branch, Indiana, which is basically the southwest corner of Indiana, right on the border with Illinois. Okay. And we're back in December of 1998. And what happened was, on December 17th, 2 sheriff's deputies led a drug-sniffing dog through the parking lot at Gibson Southern High School. So one interesting thing to note here is that December 17th, 1998 was just 3 days before the end of the first semester. All right. So 3 days before the end of the first semester, 2 sheriff's deputies led drug-sniffing dogs through the parking lot.
Right? Looking for early Christmas presents.
I guess so. Let's just stop real quick and take a minute and talk about the lawfulness of that kind of search.
Right. Yeah, because having those dogs, courts have actually kind of been split on whether or not that even constitutes a search, because there's the doctrine of in plain sight, which basically means it's not a search if you can just see it. And so people have kind of applied that to smell as well. It's not necessarily an invasion of privacy if they're just smelling something. But with dogs, and because of their heightened senses, some courts have said that, yes, it's a search. But regardless, courts have typically upheld canine searches or canine sniffs of cars in the parking lot when there's not students nearby because there's not really an expectation of privacy in your unwatched car.
Yeah.
Right? As long as they're not going into the car.
Right.
It's usually pretty much, courts have been pretty deferential.
Yeah. So it's also interesting to note that earlier in the school year, there was an assembly where the county sheriff's department brought in drug sniffing dogs and showed how they could locate hidden drugs. And the students were told, this is going to happen. We're going to use this on campus. All right. At the end of the assembly, the superintendent was there and they told students, quote, if we find drugs on your person, in your locker, or in your vehicle, then we will consider that you will be in possession and it will be dealt with as an expulsion. Okay.
Okay. They're forewarned, right? Like, so this isn't a surprise. Maybe it's a surprise when it happens, but they were students were told that drug sniffing dogs were going to be used on campus, that they were going to search cars in the parking lot, whatever it might be.
Yep.
And you might get expelled.
Yes. And so guess what happened?
Somebody got expelled?
Yeah. So they used the drug sniffing dogs in the parking lot. The dog alerted on Trent Sollman's truck. So the school administrators, they pull Trent out of class and they ask him to unlock his truck, and he does. And then in the unlocked glove box, they find a plastic bag containing, this is awesome, containing, quote, a small amount of marijuana, unquote. Chris, what's a small amount of marijuana?
You're probably asking the wrong person, but yeah, that was one of my favorite things about this case is just like,
I know.
You talk about mountains out of molehills, right?
Yeah. So the descriptions of the amount of marijuana in this case was really funny. So according to the expulsion hearing officer, it was a hit of marijuana. Okay. Which is,
I don't know a lot about illicit drugs, but it's not a
lot.
Right. Well, the Trent's attorney has a even better description.
Yeah. So Trent's attorney described it as, quote, no more than one hit. This amounts to enough for one inhale. Therefore, basically what was found in Trent Sollman's truck was an empty bag with some marijuana crumbs in it, unquote. Okay.
Yeah. Marijuana crumbs. I think that's the perfect description here.
If both of these folks are describing the amount of marijuana as sort of one inhale or one hit of marijuana, it's not a lot. It is next to nothing.
Right. Which mountains out of molehills, right? Like, because that's not even enough to roll up. Like if you're, however you're like, whatever. Yeah. It's just, obviously I have a lot of qualms with zero tolerance policies in general, but this just seems so blown out of proportion.
Well, I mean, the amount was not zero, technically.
Yeah, I guess.
But anyway, so let's not dwell on that, even though it's important to just kind of note there was so little that they found. So as soon as they found the crumbs, the principal suspended Trent and requested that he be expelled. Okay. So he's suspended based on the school's code of conduct, which specifically states we have a zero tolerance policy for drugs. Right.
Mm-hmm. Which most schools did and do.
Yeah, exactly. So according to the school, Trent violated very specific provisions of the school's policy that prohibited knowingly possessing, using, transmitting, or being under the influence of any controlled substance, blah, 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 blah. Mm-hmm. Very common language that we find in school
very
policies.
Standard.
Right? Violation of criminal law, engaging in any activity forbidden by the laws of state of Indiana. And keep in mind, for all you youngins out there, this was back in the 90s and marijuana really wasn't legal anywhere in this country back then, I don't believe. So anyway, the school basically said that historically the practice has always been to impose, quote, the maximum expulsion, unquote, under the law when they are confronted with issues of drugs.
Okay.
And the superintendent testified that during his 20-year tenure as superintendent, quote, when drugs were the offense, the recommendation from the high school principal was expulsion, and in each and every case, it was expulsions, unquote. So they have a track record here.
They've got a track record, though I wonder if all of those were crumbs
of
marijuana.
Not. Probably not.
But I think it's important to recognize like these zero tolerance policies often have required suspensions or expulsions. And so there's not a lot of room for discretion here.
Right. Because then it's not a zero tolerance policy.
That's true. Because then you're tolerating
something
other
than zero.
Exactly.
It's not nothing, right? Don't do nothing. That's
Hey.
right.
That is on like the top 5 list of chalk and gavel advice.
Yeah, exactly. All right. So basically, Trent gets suspended. Don't forget, we're 3 days before the end of the semester. And this is what makes the case very interesting here. You might think it's the crumbs of marijuana, but no. It's the timing of the suspension. So on December 17th, 3 days before the semester was done, Trent gets suspended, okay? Recommendation for expulsion at that point. Because remember, these expulsion things, principals generally do not have the authority to expel students. That has to be recommended to the board and the superintendent, and they're the ones who...
Right. Or their designee, but there's a lot more process that has to be given to students before you can expel them, whereas a suspension of 10 days or less, like Jamie, you and I have kind of talked about this, the principal can do that after notice in a hearing, tell the student what they're accused of, tell them the evidence, give them a chance to tell their side of the story. That's all you need for a suspension. An expulsion needs a lot more than that.
Yeah, exactly. So he gets suspended and obviously did not complete any school assignments for those last 3 days of the semester that he had been suspended. Okay.
Now, I don't know, was that, and I don't think we know this, like, was that a school policy where you couldn't do the work? Or was it just like Trent was like, oh, I'm suspended, I'm not going to bother?
I don't think we know that.
Okay.
And
because that affects how I think about this case a little bit.
Absolutely. Because if he was given the opportunity to do that work for credit and he just chose not to take that.
Right.
But I highly doubt that is the case, because I feel like if it was, that would have come up in this.
Right. And the way they talk about it later in the court case, it sounds like the district kind of maybe not made a choice, but like felt like they had a choice about whether to allow him to earn credit or not.
Yes.
And so that would imply to me that it's the school policy to not let him make up assignments that he's missing because of suspension or expulsion.
Right.
Yeah. Okay.
So he gets an expulsion hearing before the expulsion examiner on January 29th, 99. Okay. So this is
about a month later.
Yeah. After the suspension. Okay. And the expulsion examiner issues a report that Trent would be expelled for the remainder of the first semester and all of the second semester and for all of summer school. Okay?
Oh, wow.
So it's basically like we're recommending that he be expelled sort of in arrears, right, for first semester, because that's already done.
Right. From the moment that they found the suspension started. Yeah.
Yeah, exactly. All of second semester and all of summer school. Okay.
Wow.
So,
okay.
And would be allowed to re-enroll the following year, the 1999-2000 school year is when Trent could re-enroll. Okay. That would be his senior year, technically.
Well, probably not if he's missing an entire year.
Well, yeah, that's what I mean. Like, so maybe the opposite.
It'd be his 12th year of school.
Yeah, it should be his senior year.
Right.
Okay. So Trent, not necessarily very thrilled with that outcome.
Understandable.
Yeah. And so he requests a hearing before the school board. So this is where things start to get a little strange, because the school board holds a hearing and decides to send it back down to the expulsion examiner for further consideration. It sounds like what the courts do all the time.
Yeah, like
yeah,
we
don't
we're not
going to deal with this. You look at it.
Go try again. Yeah. You didn't get it right. We'll give you a second chance, though. That's really interesting.
Yeah.
What was there, like, why did they send it back?
So the board basically had an issue with a section or a part of the examiner's report that said, whether Trent knew the marijuana was there or not, he's still responsible for the contents of his vehicle. Oh, does that sound familiar, Chris?
That sounds really familiar. So that's, what was it? Seal versus Morgan, which we did, I think it was episode 9. And in that case, the student was disciplined for having a knife in the car that he didn't know he had because another student put it in there.
Yes.
Or left it in his car.
Yes.
And the court ends up throwing out that expulsion for having a knife because the court basically says, if he didn't know he had it, he couldn't have not had it. Well, so there's no reasonable justification for punishing him for something he didn't know he had.
Yeah, exactly. Yeah. How can you get in trouble for something you didn't know you did?
Exactly.
Right. Yeah.
Okay. So the school board is kind of like, maybe the school board had read Seal v. Morgan. I don't know if the timing works out there, but they're like, wait a second. There's this issue here about zero tolerance and due process.
Right. Yeah. So they basically said, wait a second, we don't know if he really knew he had these crumbs left. And for all we know, he thought he finished off the bag. He was completely stoned and he thought he was done.
Thought he threw it away.
Yeah.
Or
Like,
maybe it's a COV
left.
Morgan. Maybe it's a COV Morgan situation where
it was a buddy's bag.
It was my buddy's marijuana.
Yeah, it wasn't mine.
Yeah.
Okay. So basically, although fun to discuss, none of it matters.
Yeah.
Because the expulsion examiner considers the case again, drafts a revised report, which apparently concluded that Trent did indeed have knowledge of the marijuana in his truck, and once again determined that Trent would be expelled until the fall semester of the next school year.
Okay, so Trent got a second chance at the expulsion examiner, but they came up with the same conclusion.
Yeah, exactly. So Trent goes back to the school board again, and this time they vote to uphold the examiner's expulsion determination. So Trent is expelled officially, and this is really important. The school does not award him any academic credits for the first semester.
All right. This is where this case loses me.
Yeah. Okay. So don't forget, he was present for the entire first semester except for the last 3 days, and he's not getting credit for anything from that semester. And according to Trent, even if he was given zeros for all of the things, the exams, the tests, whatever he had during those last 3 days, he still would have done enough to earn passing grades. That's according to him.
So even if he got the zeros, he should have still gotten credit. But because of the expulsion, the school just said, we're not going to give you credit for first semester because you were expelled during first semester?
That's what they said. Yes. Yeah.
Yeah. So I'll put my soapbox down for a second.
But I'm going to hand it over to you, Chris, at this point.
Well, let me get my soapbox back.
Trent was honestly, he was unhappy with this decision, which tends to happen about the halfway point in every Chalk and Gavel episode. Somebody's not happy.
And like any good litigant, he files a lawsuit.
There you go. So what happened, Chris?
So Trent files this lawsuit against the district in Indiana State Court. So we're in the State Court of Indiana right now at the trial court level. So he is arguing that essentially his expulsion was too long. It exceeded the length allowed under Indiana law. He argues that his expulsion was arbitrary and capricious, which is a very important phrase in due process. And then he argues the refusal of the district to give him credit for the first semester was also arbitrary and capricious. So Trent is essentially asking the court to end his expulsion after the second semester. He's not contesting he's not contesting kind of the substance of the expulsion.
Correct.
Yeah. He does a little bit where he kind of says like, I didn't get enough due process and, that sort of stuff, but it's not really front and center. But he just wants the expulsion to end after second semester before summer school. And he wants the school to be ordered to give him his grades and credit for the first semester.
Okay.
For the work that he had done before he was expelled.
Seems like a relatively reasonable request.
As these lawsuits go, right? Like that seems to be one of those where the school and the student can just kind of like shake hands and walk away, right? But that's not what happens because this is a lawsuit. Well, no, because lots of people settle lawsuits. I don't know why the district didn't do it. So Trent asked the court to basically end his expulsion after the second semester, allow him to roll in summer school, and then also asked the court to order the school to give him his grades and credits for the first semester.
Okay.
So like, his ask here is not, it doesn't seem that unreasonable, right? Like, he's not saying you never should have expelled me or suspended me or whatever. Like, it's just, hey, you went too long. And then also, can I please get my grades for first semester for all of the work I did for the other 87 days of the 90-day semester or whatever?
Yeah.
So the school, I guess, wasn't up for accepting that compromise. So the case goes all the way through trial. And the trial court concludes that while the school had the authority to expel Trent for the remainder of the school year, Indiana law defines the end of the school year as the end of second semester.
Oh.
So the court says, nope, you can't expel him for summer school. The expulsion can't continue into summer school.
Interesting.
And the trial court also says that it was arbitrary to deny Trent credit for work that he had already completed prior to his expulsion. So, to me, that kind of makes intuitive sense. Like he already did the work.
Yeah.
If he would have earned passing grades for the work that he'd already done, it seems really arbitrary, again, to use that word, to deny him credit for work that he'd already done because he got disciplined for something unrelated to his academics.
Right. Now, listen, if the courses that he was taking were set up such that the exam that occurs on the last day of the semester is worth 90% of the grade, of the course grade, right? And he misses that exam and ends up failing the course because of that, maybe we've got a different situation here, because then based on how the grading structure was set up that he would have known of or would have known about, right?
And the court kind of addresses that because they basically say, give him zeros for everything that he missed and give him the grade he would have gotten.
With those zeros at the end.
With those zeros, yeah. So like if the final exam is 50% of the grade, then he's probably not going to pass.
Right.
But at least the court kind of says, like, don't take away the stuff that he already did.
Yeah. Okay. Well, that seems to make some sense.
Right. And like, the school kind of wins here too, right? Because they not got to expel, but their expulsion was upheld, right? It didn't go as long as they wanted it to, and they have to give them credit for the first semester. So this is another one of those cases where I'm like, I'm confused at why the school is continuing to pursue this, because that is not the end of this case.
Okay.
And instead, the school appeals that outcome to the Court of Appeals of Indiana. So this is the Indiana Intermediary Court. So we're at the appellate level before we get to the Indiana Supreme Court.
It's just interesting, like that the school, it's not like the school
they
lost
didn't really
big
lose,
time,
right?
Right? Like they still get to suspend the kid. There's nothing wrong with the policy in terms of, the zero tolerance policy. They found drugs. He was suspended. Nobody's really arguing with that. They're basically saying you can't suspend him past the end of the school year and just give him credit for the stuff that he did. And instead of the school going, all right, fine.
Yeah, that seems fair.
Right? They said, nope, we need to appeal this decision.
We need to appeal this.
Okay.
And so they appeal it, and the appellate court, the first appellate court, affirms the decision. So they also conclude that the school can't expel a student beyond the end of the second semester under Indiana law, and that it was arbitrary to deny a student credit for coursework that he completed prior to his expulsion. So looking at the court's reasoning here, Indiana law at the time said that students who are expelled during the first semester of the school year may not be expelled for a longer period than the remainder of the school year in which the expulsion took effect. And then further, the school year was defined as the period of time beginning after June and ending before July 1, except when a different period is specified for a particular purpose. And the court basically looks at this and says, well, second semester ends before July 1st. Summer semester is going on during that time period. So it can't be at the end of the school year, can't be at the end of summer semester because that's after July 1st. Therefore, the school year ends with second semester.
Okay.
Great example of statutory interpretation.
Uh-huh.
And so that one I think is pretty cut and dry. The other one about whether or not to award Trent academic credit for first semester, this is a little bit trickier. And it all hinges on some more statutory interpretation. So the school board argued that basically the school board is arguing that we had to deny him academic credit for first semester under Indiana law. So they're kind of saying like, look, our hands were tied. Indiana law says we can't give him credit if we expel him for the entire semester, regardless of when we expel him.
Okay.
So under Indiana law, an expulsion means a disciplinary action where a student is separated from school attendance for the balance of the current semester or current year, unless the student is permitted to complete required examinations in order to receive credit for courses taken in the current semester or current year.
Okay.
And that is not the best phrased law, because there is an argument about what it means for in order to receive credit for courses taken in the current semester or current year. So the district is reading that as saying, if we don't let them take exams, then we can't give them credit, because in order to give them credit, we have to let them take the exams. That's the district's reading. So it all comes down to, what does that in order to receive credit modify? To me, it modifies it basically tells you the purpose for allowing someone to take an exam. It doesn't say, and you can't give them credit unless you give them an exam.
Yeah.
Right. So that's what the appellate court here says. The appellate court says that, no, the natural reading of the statute is that you can give them exams in order for them to earn credit if you want to. So you have discretion to allow them to take exams, it doesn't
say anything about what you've already done.
Right. It doesn't say you can withhold grades that have already been earned. Exactly. Right. Yeah. So the board is arguing that, they had to keep that credit back because they didn't let him take his exams. The court says no. The court says that ignores the plain language of the statute. The statute says that you may give credit. It expressly allows schools to permit students to take exams while expelled. It doesn't say that you can deny them credit for completed work. And it also doesn't say you have to deny them credit for completed work.
Right, exactly.
So undeterred, though, the school makes another argument. They say, yeah, maybe that's a better reading of the statute, but it's good public policy to allow us to deny the student credit for the semester in which they are expelled, because if we don't, then students who are expelled earlier in the semester will have less of a chance to pass the courses than students who are expelled later in the semester.
But isn't that okay? Like, that's how it goes, right?
Right. Well, the school's kind of making some like really interesting arguments here about like students willfully breaking rules. And so they're basically saying like, we don't want to give students incentives to break the rules when they've accumulated enough of a cushion to pass a class.
Okay.
Right? Because like, they'll hit that 61% or 71% or whatever it is. And they'll be like, okay, well, I'm passing now. Nothing that happens to me after this will affect my grades. So I'm going to bring my marijuana to school.
I don't know if that
is how people think.
Like, you know what? I don't know if Trent Sollman would have been thinking like, well, I only have 3 days left here, so
it doesn't matter if I get in trouble, right?
Yeah, like, especially because when it comes to drugs or whatever, do they think that they're just going to, hey, it's only 3 days left of the semester. If they suspend me, they're just going to suspend me for 3 days, right?
Because they know they're getting expelled. There was an assembly of
exactly. They're done for the year, right? I don't know.
Yeah.
I mean,
I think a lot of these court decisions, a lot of the arguments seem to be, I guess, don't accord with how I think people think. The court kind of like wraps this all up and says that, so according to the court, quote, to further punish the student by stripping him of credit for work performed while in good standing at the school is simply wrong. Nice, clear statement. Love it when courts do that. The court goes on to say that, after all, the goal of our schools is to educate our children. When students with disciplinary problems interrupt this goal, appropriate action must be taken to maintain order in the school, including expulsion if appropriate.
Okay.
However, expelled students may be expelled from education in many of our communities. For those students to be denied credit where credit is due runs contrary to the purpose of an educational institution, and such a denial under the circumstances of this case is arbitrary and capricious. And I really like this phrase by the court because it highlights the educational mission of the school. And I think that's what I'm really kind of hung up on is this student engaged in misbehavior unrelated to academics, right? He brought drugs to school.
Right.
And no one is questioning the school's authority or ability to punish a student for bringing drugs to school. Mm-hmm. What they're questioning is whether or not you can take away someone's academic credit for stuff that they've already done because of that. And I think that the appellate court here kind of makes a very simple case that's wrong, right? Like, schools exist to educate. And here, the school seems to be prioritizing punishing a student for their conduct over their educational mission. And I think that's what I'm really hung up on.
Yeah. That I see that.
And I wish that was the end of the episode, but it's not.
And some of our listeners probably wish it was the end of our episode too.
No, this is edge of your seat stuff. So the school doesn't like that outcome again and appeals it to the Indiana Supreme Court, and they see things a little bit differently.
Oh.
Yeah. So they actually side with the school.
Okay.
So they find the exact same conclusion about when the school year ends, and they say, look, you can't expel Trent past second semester, so whatever credit he got for summer school, we're going to let that slide. But they look at this question of whether or not it was arbitrary to deny Trent his grades for first semester, and they say that, you know what, the school's got it right.
Or do they say that, or do they say we can't see that it rises to the standard of being arbitrary?
The Indiana Supreme Court, Jamie, to your point, is asking whether or not this rises to the level of being arbitrary and capricious governmental action, meaning that it has no rational basis.
Right.
And that should sound really familiar to our listeners because that's the baseline for all governmental action under the Due Process Clause.
Right.
All government action has to be rationally related to a legitimate governmental interest. And that's a really easy standard for the school to meet. So it's on the student to prove that the government's action was arbitrary or irrational.
Irrational, right. Yeah.
And here the Supreme Court, the Indiana Supreme Court, finds that the student didn't prove that the school acted irrationally.
Okay.
So to determine if the decision was arbitrary, the Supreme Court starts again with statutes. They look at the school's authority under Indiana law, and under Indiana law, schools have the authority to take any disciplinary action necessary to promote student conduct that conforms with an orderly and effective educational system. And that's a massive.
Wow, that's big.
That's so much discretion, right?
Any measures they feel necessary.
Right. And the court views that as incredibly broad, which it is, right? And so, that starting with that very broad grant of authority, the question that the court is asking here is like, okay, with that broad grant of authority, is it rationally related to the school's interest for them to deny credit? And so looking at the statute that we talked about earlier, they look at that in order to receive credit option that districts have. And they kind of say that the school didn't have to deny him credit, but it could have under the statute because they denied Trent the opportunity to take his final exams for the first semester. So they view the statute as kind of like allowing for you to deny credit.
Yes.
Not that you have to, but that you may.
But you may
if you
based
don't.
on the statute. Yeah.
Yeah. And, I don't think that's the best reading because, I kind of agree with the appellate court here. But in, this kind of goes to our conversation earlier about this calculus about whether or not it's reasonable to think that denying students credit for work they've already done is going to be a deterring effect. There's this quote from the court where they say, in order to promote student conduct which conforms with an orderly and effective educational system, a school board could understandably reach the conclusion that the deterrent of expulsion, uncoupled from a loss of credit, meaning that we're not going to take away your credits, may not be a sufficient deterrent enough for a student to avoid being expelled. So if a student knows, for example, that the ultimate consequence of violating school policy is expulsion only, then the student may assume the risk of getting expelled where he was already accumulating sufficient grades to pass the semester. So that's kind of the argument that I was poking fun at earlier, right? Like that someone's going to be like,
if you don't take away credit, there's no incentive.
Right. Which ignores the fact that there's still an expulsion attached to all of this, right?
Yeah. And they're not going to school for an extended period of time.
Yeah. Right.
And they're going to lose a significant amount of credit.
Right. So it's kind of like hitting them with a double whammy.
Yeah.
Right? Because, they're going to miss all the credit moving forward.
Right.
Maybe not the credit that they've already gotten.
Right.
Yeah. And so ultimately, the court concludes that it can't say that there's no reasonable basis for the school's actions, so Trent's claims fail. Now, the thing that really, again, kind of kills me here is the court doesn't really grapple with the fact that this is credit for work that has already been done.
Exactly.
Rather than work that he missed because of the expulsion. And, it might not be sound educational practice to deny student work during expulsions and suspensions because that, like Jamie just, I just said, that's kind of a double whammy, right?
Yeah.
You're missing school and you're also missing out on education.
Right.
But there's this distinction between stuff that you've already done. And so to me, if you look at this through the lens of due process, where it has to be rationally related to a legitimate interest, like the legitimate interest here is deterrent. I don't think there's a good argument for losing credit you've already accumulated to be a deterrent. But I think the stronger argument is that by completing the work and earning the grades, there's a property interest that kind of attaches to that. Where like basically you've already done enough to earn the stuff. And so the government can't just arbitrarily take away stuff that you already have, right? That's the entire purpose of procedural due process.
Right.
And so if we're thinking about this from a due process lens, then you would ask like, what's the student's interests? What's the school's interests? And, was there a sufficient justification to take away this stuff based on those interests? And I hear like, because of the school's educational interests, I think that definitely weighs in favor of giving the student credit. Obviously, that's not what the court did. The court said, yeah, it was fine to deny Trent credit for first semester. But, in the context of graduation, like if students misbehave at the end of the school year, typically the punishment isn't to withhold their diploma.
Right.
And a lot of courts who have addressed that have said like, look, if they earned enough credits to get their diploma, you can't withhold that. You can keep them from walking at graduation.
Sure.
But they earned that thing.
Right.
Let them have it.
Right.
And I think this to me is the same thing. Like, they earned it. Let them have it.
Yeah, this is a strange case. I don't know. I can see it from both perspectives. I can see it from one perspective a little bit more than another, right?
Is it because of my eloquent defense?
Yeah, I mean, that contributed to it. Yeah.
I'm going to put my soapbox away.
Yeah, no, I mean, I think it does feel pretty arbitrary to me to deny somebody the credit for things that they have already earned by simply saying, if we don't do this, there's no deterrence. And I don't agree with that.
Or not enough deterrent.
Yeah.
Right?
And I don't necessarily agree with that personally. But I think it one of the things that is a big takeaway for me from this particular case and this particular episode, and the thing that I would like to put out there to everybody is this reinforces the importance of knowing your state regulations on these kinds of things, because as this case demonstrates, the courts looked repeatedly at what the state statutes said about all of these issues and used those statutes as a guideline. And I think in a lot of states, the statutes specifically talk about how schools can and should approach academic credit during long-term suspensions and expulsions and things like that. All right. So hopefully your school boards have also read through those regulations and adopted policies that are in compliance with those regulations and are also not arbitrary or capricious or...
Right. Yeah. Because the school, felt like they had to take this action. And, it sounds like they were coming down hard on illegal drugs and that, that was something that they were being very serious about. And so, if you're cracking down on that and that's what your school policies, or you feel like that's what state law requires you to do, yeah, I guess I can see where they're coming from. And I will never argue that you shouldn't be aware of your state's laws and policies around this, because that gets districts into trouble a lot when they aren't on top of those things, especially around things like due process, because they're so laid out in state statute where it's a really easy place to trip up.
Mm-hmm.
Poor Trent.
Poor Trent. We don't know anything else about Trent.
Just that he was allowed to go back to school for summer school.
Yeah, exactly.
Yeah. Hope he graduated on time.
Hope Trent's doing all right. Yeah. So there you go. That's the South Gibson School Board versus Trent Sollman, 1998, or at least that was when the whole thing started. When did the Supreme Court rule on this thing? What did it say?
When did the Indiana Supreme Court rule? Good question. In 2002.
Okay. 4 years.
Nice. That's pretty quick.
3 years, because this was like the very end.
99 is when it was filed. Yeah.
Yeah. So relatively quick. Good job, Indiana. Okay. So,
yeah, he was probably in college by then if he went to college.
Yeah. If his expulsion did not prevent him.
It was on his permanent record.
Yeah,
right.
Exactly. All right. So there you go, folks. That is that case. And we got more coming for you in a couple of weeks. But until then, Chris, what's the homework?
All right. Your homework is to make sure you don't leave any crumbs in your car and
just throw them out.
Just throw them out. And to like, rate, and review Chalk and Gavel wherever you get your podcasts. Check us out on our Patreon, patreon.com/Chalk and Gavel. Your support means the absolute world to us. And we look forward to seeing many of you at the Education Law Conference in sunny Orlando in November.
All right. Well, that's it for us for this time. We'll see you again in 2 weeks with a fun case, also referencing drugs. So tune in.
Yeah, get ready for some bong hits for Jesus.